Hello everyone, this is Bindu Sharma from Origiin IP Solutions, a Bangalore-based company dealing with IP and legal services, and we mainly work in the area of patents, trademark, IP landscape. I'll explain you how to spot right IP in your product, what are the different kinds of IPs, and how do you document the details required to file intellectual property, and some resources I will give you which you can go through whenever you have time. So intellectual property, as the name suggests, it's creation of mind. So any creation of mind will get protection only if it has value. So it's exactly the same way you buy a new house, you buy a land, you have to register it, right? So in order to claim rights over your intellectual property, you have to register it. If you have not registered it and published it, then it is meant for everyone to be used without your consent. So the difference between registered and unregistered IP is that you can claim ownership over registered IP. Now, your IP may be of different kinds, like it may be a book, it may be a drug formulation, it may be a device to measure your blood pressure. So depending upon the kind of IP you have, we have different frameworks to protect that IP. The most talked about form of IP is patent. So patent is granted for a new product or new process, which is inventive in nature and which has industrial application. And trademark is brand name, name of your company, name of your services, name of your business, name of your products. So all of them, they are registered as trademark. Some of the famous trademarks may be Adidas, Baskin and Robbins, Biba women apparel brand, MDH Masala. These are all our trademarks. So your trademark may comprise of the name, logo, and it may or may not have a tagline. Okay. So copyright is a kind of IP which is granted to your e-commerce platforms, probably the software program code, books, periodicals, journals, documentaries, musical work, videos, YouTube videos that you are creating for your business. And then comes another form of IP called as design. So design is granted to aesthetic look and feel of the product. So design may be granted to design of your footwear, design of your jewelry, the dress, watch, mobile phone. So aesthetic look and feel of a product is protected as design. Now coming to another form of IP which is very, very interesting, trade secret. Okay, every business has one or the other trade secret, but most of the companies get to know about value of trade secret only when they lose it. Otherwise, trade secret is most of the times not really identified well in time. Most famous trade secrets, if I have to name some of them, Coca-Cola, then your KFC chicken masala, McDonald's aloo tikki. So food industry especially is full of trade secrets. So you must identify right kind of IP in your product, and one product may have multiple IPs. Like if you take example of my cell phone, design of a cell phone can be registered as a design. There may be internally some layouts, chipset designs and all. They are protected as semiconductor chipset designs. Then the brand name, if it is Samsung, Apple, so brand name is a trademark, and there are lots of technologies running inside, and there may be a patent. So you must be able to identify right kind of IP, and mostly people think that it's only one IP that can be registered for a product, but there are multiple IPs that go in the same product. So if it is a pharmaceutical formulation, then formulation is a patent, whereas design of a bottle may be registered as a design. Name of your molecule may be a trademark. Okay. Now, when we are working with inventors, we find it very difficult to extract right details about the invention from the inventor. The reason being that the inventor would have worked on the invention for multiple years, maybe it's hard work of 9 years or 10 years. So giving details to a person who is stranger is very difficult, and they are very, very possessive about their inventions. So what is the right way to get the details extracted from the inventor? So I feel, in my personal experience, NDA is very important. So you should first of all have non-disclosure agreement, so that the inventor has confidence in you that he can disclose details to you. And secondly, you should have a very good invention disclosure form wherein all details are there to be filled by the inventor. First section could be the contact details of the inventor, followed by the details of the invention, and based on that you can suggest him that you should go for your India patent first, and if there is a market in the foreign countries, then he can go for a foreign patent as well. And another thing which I have realized while dealing with a lot of inventors is that most of the times inventors are lazy filling invention disclosure form. You give them best idea, but they will not fill it. It will come to you today, tomorrow, and so on, and the idea really gets delayed. So one of the things you can consider is that you meet the inventor, and you can even record the call if he permits. You should always take permission before recording any call whatsoever. And if the inventor is comfortable, you are comfortable, then record his call, and you delegate a person to take disclosure of his invention. So this really fast tracks everything. Okay, so then inventor is also comfortable disclosing details to you, and you have invention disclosure form, and you can fill the invention disclosure form and get it verified from him. So this way, I think IP filing process can be really fast tracked. And when we are filing a patent application in India, it is mandatory actually to file patent application first in India, because we have a very important section in Indian patent law, section 39, which says that if you are resident of India, you must first file your application in India. If you are not interested in filing application at all in India, then you have to seek permission from the controller to file your application outside India. This is to ensure national defense and security. Once you have filed your application in India, within 12 months from Indian filing, you can go for any kind of foreign filing. So that's how holistically you can look into the product and find out what is the right way of filing IP, and then proceed with registration of IP. Now, apart from patent, if it is a copyright, so in copyright, the process is fairly straightforward. There is something called as Berne Convention, wherein around 170 or 75 countries are the member states. So there is a clause in Berne Convention that you register your copyright in any one country of Berne Convention, and you automatically get protection in all the member states of Berne Convention. So this means that if you registered your copyright in India, it is valid in 175 countries who are member states of Berne Convention. And your trademark design also have to be registered in every country where you want to do business. Okay, and when it comes to trade secret, it is a very different and unique form of IP. Since you cannot disclose your trade secret, see, when you are filing for a patent, design, or trademark, you have to disclose to the respective IP office that this is what you want to register. But since trade secret cannot be disclosed, so it cannot be registered. So how you should protect your trade secret? There have to be various measures you have to take. It's exactly the way you maintain your own secrets. The best way to maintain my secret is I don't disclose it to anyone. So similarly, if you have some secrets in your business, the best way is not to disclose to anyone. So in your company, you have to delegate a particular area where that secret is going to be used, and then everyone who is going to access that secret has to be bound by the agreements, and you have to be really creative in finding out the ways to protect your trade secret. We work with a very interesting company. I cannot name it right now, but they have one particular floor dedicated to new designs and new compositions that are coming out of the company, and they are trade secrets. So the lift does not open in that floor, and nobody is supposed to enter that floor. Names of people who can enter that floor, they have been put on the entrance itself, so that security guard knows that apart from these 5 people, 6 person cannot enter, and those 5 or 6 people also, they are not supposed to interact too much with each other. So that means one secret split into 5 parts. 5 of them, they know what they know, but nobody knows the entire secret. And since lift does not open on that particular floor, so if you have to climb to that floor, you have to either go up or down and climb to that floor. So this way you can maintain secrecy of your trade secrets. In fact, trade secret is a very interesting area, and every business must explore, because trade secret, unlike patents, is perpetual. As long as you are able to maintain secrecy of your trade secret, it remains as a secret. But once it is out, it is gone forever. You cannot retrieve your trade secret back. Even if you file lawsuit, you win any lawsuit of trade secret, but your secret is gone, and it's gone forever. So just to conclude, I would like to say that whenever you have new product, find out all possible ways to protect your product, especially if it is commercially very important. Then you must do all possible things to protect your IP. And if IP also includes a trade secret, then you don't have to spend any money to protect this trade secret, but only thing you need to do is to find out creative ways to protect your trade secret. You can check some of the official websites of Indian Patent Office, then World Intellectual Property Office, then US Patent Office. They do lots of webinars from time to time, and they are very good resources to know more about intellectual property. And at Origin, we have released a lot of books, free books on intellectual property rights.